Hi everyone, welcome to the second recorded lecture on hearsay in criminal cases. And this one is going to focus on section 118 of the Criminal Justice Act 2003. Now, if you recall, under section 114, it states that hearsay is inadmissible unless it falls within one of the exceptions. And section 118 provides for the common law exceptions. And this is going to be the focus of the short presentation today. So at the end of this PowerPoint, you're going to be able to identify the common law rules that have been preserved in section 118, subsection 1. And you're going to be able to identify how they apply, with particular focus on the one understood to be re gestae. So here's section 118. Yes, as you know, as I've said, it preserves a number of common law rules, a number of which you would have come across, confessions and expert evidence. Now, the focus here is going to be on re gestae, and that's what I'm going to go on to talk about. But I just want to provide you with an overview of the other rules that have been preserved in section 118. So as you can see on the slide in front of you, you have the first one being public information. Now, public information relates to any published works that deal with matters of a public nature. So they could be historic works, they could be maps, they could be dictionaries, and they're all admissible as evidence of the facts of a public nature that are stated within them. They also include public registers, so registers of births and deaths and marriages, records of the court, treaties, pardons. All of these things are admissible as to the truth of the facts stated in them. The next common law rule is reputation. So we've got reputation as to character. Now we're going to be looking at good and bad character in a week or so. But for the purpose of section 118, evidence of proving a person's good or bad character can be in the form of a witness being called to give evidence on general reputation. Reputation as to family tradition goes to proving or disproving pedigree, for example, or the existence of a marriage. These things are hearsay, and they fall within the common law rules that have been preserved by this section. Re gestae, we will go on to discuss. Admissions by agents, you can see, is underneath re gestae. And that concerns things like confessions that have been made on the defendant's behalf by his solicitor or by his barrister, which are the agents in that case. And the rule of law that's preserved essentially here is admissions by agents of the defendant become admissible against the defendant. Common enterprise, a number of you will have come across, more colloquially understood as joint enterprise, is as one of its forms. And that's any rule of law in which a statement made by a party to a common enterprise is admissible against another party to that enterprise as evidence of the matter stated. Now, the conditions here are that the statement must have been made in furtherance of the common enterprise and in the course of the common enterprise. But such a statement can be used as evidence of another party's participation without any independent evidence of that fact. And finally, you have expert evidence. So in an expert, when they're given evidence in court, they may draw upon the body of expertise that are relevant to their field. They can rely on works of authority, which would be regarded under common law as hearsay. So as you can see, you've got a number of common law rules. It's necessary to refer to the common law to determine the applicability of each of those rules. And the one that we are now going to go and focus on is the one that is known as re gestae. So Ragesa essentially concerns statements that are so closely connected to the particular event that the possibility of that statement being a lie or being a mistaken statement are so minimal. And it's been found that these statements are more likely to be reliable than any other hearsay statement. And there are three types of Ragesa statement. So the first is a spontaneous statement. Then you have statements that accompany an act, and then statements relating to a physical sensation or a mental state. Now, spontaneous statements are statements that have been made by a person who is so emotionally overpowered by an event that the possibility of concoction or distortion can be disregarded. Now, spontaneous statements in this context are often referred to as excited utterances. And the case of the Crown against Andrews is the leading case that provides the meaning of spontaneous. Now, in the Crown against Andrews, the victim was attacked after someone knocked on his flat door. He answered that door, and after being wounded, after being attacked, and finding he was wounded, he made his way to a neighbour's flat. And when the police arrived, he told the officers his attacker was called Donald. Now, the victim subsequently died from his wounds, and those police officers who came to the flat and who heard what he told them were called to give evidence of the statement that he made. Now, the trial judge and the Court of Appeal both held that whilst the statement was hearsay, it was admissible as a Ragesa statement. And it was Lord Ackner that delivered the leading opinion. And he stated that in an application to admit under Ragesa, the judge needed to consider the following points. So the judge needs to ask whether the possibility of concoction or distortion can be disregarded. There must be consideration given to the circumstances in which the statement was made and whether it was sufficiently spontaneous. The judge will have to decide whether the event was still operating at the time of the statement and whether it dominated the thoughts of the victim to the extent that the statement was an instinctive reaction and there was no opportunity for reasoned reflection. Now, the Crown against Turnbull is another example of a Ragesa statement, and we'll be discussing this when we do identification evidence. But essentially, in Turnbull, the defendant was charged with murder, and on that night, after he had stabbed the victim staggered into a pub, and as he fell on someone inside that pub and someone caught him, he was heard to say by a number of people that Tomo had stabbed him. Now, Tomo was found to be the defendant's nickname, and the statement was found to be admissible at trial as Ragesa because it was so closely connected in time and place to the event that the risk of distortion and concoction was negligible. Now, a Ragesa statement that accompanies an act can be properly evaluated as evidence only if it is considered in conjunction with the statement. So there needs to be an evaluation of both the act and the statement that was made. Now, the Crown against Edwards concerns a defendant that was charged with the murder of his wife, and a week before the wife went to a neighbour and asked them to look after a carving knife and an axe. And she told the neighbour that this was because her husband had threatened to kill her with them, and she was worried about having them in the house on that basis. Now, after she was killed, This statement that was made to the neighbour was found to be admissible as Ragesa because it was an explanation of handing the weapons to the neighbour, which became very relevant to the case. Another Ragesa statement is where the statement relates to a physical sensation or a mental state, such as an intention or an emotion. And the statement must be closely connected to the physical or mental state. And the Crown against Guilfoyle is used an example here, where the defendant sought to adduce suicide notes written by his wife as evidence of her suicidal state of mind. Now, the deceased had also informed friends that her husband had asked her to write these suicide notes. And the Court of Appeal found that these statements from the wife's friends were admissible as evidence of the state of mind of the deceased, of the wife, to show that she was not suicidal because they related to her mental state. So as you can see, and going briefly back over Ragesa, it is fairly simple in the context of what you have to look at. So you have spontaneous statements, statements accompanying an act, and statements that relate to a physical sensation or a state of mind. In itself, it's quite a small area of law, but it might be one that you come across in your problem question. So next week is our final week on hearsay evidence in criminal cases, and we're going to be looking at hearsay and the right to a fair trial. See you next week.